Okay, hello everyone. Good afternoon, everyone. Welcome to HHQ webinar. We are glad to have many esteemed attendees with us today for our webinar on employment law and proper procedure and termination of employment in Malaysia. My name is Aini Ajira, a pupil in Chambers of Halim Hong and Quek, and I will be the moderator for today's session. Before we kickstart this session, please be informed that all participants will be muted. If there are any questions, please type in the Q&A chat box and we will discuss them during the Q&A session later. And also, please scan the QR code appeared on the screen for your attendance. Now, please allow me to introduce our speaker, Mr. Rohan. Mr. Rohan is a partner of Messrs. Harold and Lam Partnership. Mr. Rohan here is principally involved in dispute resolution. His core areas of practice are construction and engineering and employment in labor related to disputes. Now, besides disputes resolution, Mr. Rohan also has the experience in providing advisory services in respect of construction and engineering contracts, employment contracts, and even commercial contracts. Now, please join me to welcome our speaker today, Mr. Rohan. Mr. Rohan, please.
Thank you, Aini. Good evening, ladies and gentlemen. Thank you for joining this webinar, for taking time off from your busy schedule to join this webinar. And I would also like to thank our alliance partner, Halim Hong and Quek, for organizing this webinar and for inviting me to speak at this webinar. So at today's webinar, I will be taking you through employment law, and in particular, the procedure relating to termination of an employment contract in Malaysia. I've prepared some slides. My slides are actually quite lengthy. It's quite voluminous. And given the fact that I only have 1 hour, so I will focus on the key areas relating to termination. But before I go into the area of termination, I will just take you through briefly some of the basic aspects of employment law in Malaysia. Now, I always tell everyone, my clients, or whenever I speak at a webinar, I always tell the participants that employment law is an area that all of us should know, at least have some basic understanding, simply because all of us are either employers or employees. So it's very important for all of us to have at least a basic knowledge on employment law. So now, let me just start off by taking you through the types of contract. Yeni, can you just move on to the next slide? Yeah. Now, there's always been some confusion as to the types of contract which constitutes an employment contract, whether it's a contract of service or a contract for service. Now, what is a contract of service? A contract of service is an agreement whereby one person or one party agrees to employ another person as an employee. So where an organization enters into a contract with an individual and that organization agrees to employ that individual as an employee of the organization, and that individual agrees to serve the organization as an employee. That constitutes a contract of service, and a contract of service for all intents and purposes is considered an employment contract under Section 2 of the Employment Act 1955. And a person who is employed under a contract of service enjoys statutory protection provided by the employment laws in Malaysia. And in the event there's any breach of the person's terms of employment, then that person can actually seek appropriate remedies either in the labor court or in the industrial court. So most of you who are employed in an organization, like those of you employed by Country Garden, your employment or your engagement by Country Garden would constitute a contract of service. That's an employment contract. Now, on the other hand, we also have a contract for service. What is a contract for service? A contract for service is where a party engages an independent contractor to carry out a particular task or particular assignment for a fee, for a remuneration. An example that I can give you is where, as a homeowner, there are some issues with your electricity supply in your house. For example, there's a faulty circuit in your house. You then engage an electrician to undertake some repair works, and you pay him for his services. This would constitute a contract for service. And when it comes to a contract for service where you engage an independent contractor to carry out a particular service, a particular assignment for a fee, if there is a breach, for example, all the independent contractor can do is to seek appropriate remedies for breach of contract. So for example, you enter into a contract for service with a contractor, you engage the contractor to carry out some services at your house, for example, to mend a faulty circuit, and you agree with him that you're going to pay him so much for his services. Then after he has carried out his services, you don't pay him as what you undertook to, as what you promised. Then that independent contractor can seek remedy for a breach of contract. But that contractor cannot bring any claims against you in the industrial court because a contract for service is not an employment contract under the law. Now, moving on from the types of contract, I will now deal briefly with the types of employment. Broadly, there are two types of employment. One is a permanent employment, and the other is a fixed-term employment. Now, dealing with permanent employment, what is a permanent employment? A permanent employment is where an organization engages an individual under a contract of employment, where there are express or implied terms set up. This is basically your contract of employment, which contains various terms, such as wages and terms relating to your wages, your leave entitlements, your healthcare benefits, and also your contributions towards a retirement plan, such as your EPF and SOCSO. A permanent employee, however, does not enjoy employment for life. So if you're employed under a permanent contract, it does not mean that you are going to be employed for your lifetime. In most employment contracts, there would be a retirement age. So once you hit your retirement age, your contract of employment would naturally come to an end unless it is mutually extended by the employer, and as an employee, you agree for your employment contract to be extended. And a probationer is also considered a permanent employee. And moving on, we also have fixed-term employment. This is quite common these days, where many organizations, many companies, many businesses engage employees on a fixed-term employment. What is a fixed-term employment? Fixed-term employment is where a person is engaged for a specific duration or a specific period of time. And in the employment contract, there would be a start date and an end date. And the contract of employment will usually automatically end upon the expiration of the period stipulated in the contract. So for example, you enter into a one-year contract with a particular person. So your contract will say, for example, your contract has a start date of 1st January 2021 and an end date of 31st December 2021. So it's a one-year contract. The contract will automatically end on the 31st of January 2021. So that person will no longer be an employee of the organization with effect from 1st January 2022, unless that contract of employment is extended. And usually, a company or an organization will enter into a fixed-term employment for temporary jobs. For example, due to the absence of a permanent staff, you have employed somebody and that person has left. And while you find a suitable candidate, maybe you want to just employ somebody on a temporary basis for a fixed duration of say 1 year or 2 years, you then enter into a fixed term employment. Or for example, you just want to employ a person for a particular project or particular task, and that person's duties and responsibilities will end on the completion of the project. Then you may then enter into a fixed term employment with that person, where you perhaps can employ that person for the duration of the contract. It is, however, important to note that a person employed under a fixed-term employment would also enjoy similar benefits as a permanent employee. So a person employed under a fixed-term employment would also have rights to monthly remuneration, would have entitlement to leave, would have entitlement to statutory contribution by the employer. So all the benefits that a permanent employee would have, a fixed-term employee would also enjoy such benefits and would enjoy protection under the law. Now, I will now deal briefly with employment law in Malaysia. I'll just give you a general overview of employment law in Malaysia. In Malaysia, employment law is primarily governed by our Employment Act 1955, as well as our Industrial Relations Act 1967. There are, of course, other subsidiary legislation and regulations, but the two primary legislation, the two main acts in Malaysia governing employment law is the Employment Act 1955, as well as the Industrial Relations Act 1967. Dealing with the Employment Act 1955 first, this is an act which has been implemented to protect employees by ensuring that there are certain minimum standards in the conditions of employment which are maintained by the employer. For example, this act will ensure that employees are properly paid, they are paid their wages. It imposes restrictions in the deduction of wages. So once you employ a person under a contract, and say, for example, you offer the person a monthly remuneration of 5,000 ringgit, the employer then cannot just unilaterally reduce that person's wages to say 4,000 ringgit a month. In such a situation, the act will come into play and it will offer protection to the employee. The employee can then seek appropriate remedies under the law, under this act, should the employer make unilateral deductions in terms of wages. And of course, it provides other protections to the employee as well in terms of your leave, your maternity and entitlement, and etc. But there is one thing that you need to bear in mind. This is very, very important. The Employment Act 1955 only applies to employees who earn RM 2,000 a month or below. This is set out in the first schedule of the Employment Act 1955. So say, for example, you're an employee earning 5,000 ringgit. Are you protected by the Employment Act 1955? Generally, no. If you're an employee earning, say, 1,800 ringgit a month, are you protected by the Employment Act 1955? Yes, you are. Okay. So what happens to employees who earn more than 2,000 ringgit? If you're not protected by the Employment Act 1955, then what protection is provided to you? Well, for employees who do not fall within the ambit or the purview of the Employment Act 1955, their terms of employment, their employment with the employer, with the organization, will be governed by the terms of their employment contract. So for all of you who are earning more than 2,000 ringgit, your terms of employment, your conditions of employment would be governed by your employment contract. That would be the key document. That is the fundamental document which would set out your terms of employment with the employer. Right? And then I'll just move on further. Now, dealing with the Industrial Relations Act 1967. This act governs, similar to the Employment Act 1955, it governs employment relationships in Malaysia. But this act is designed to provide remedies to employees who have been unfairly dismissed or who have considered themselves to have been constructively dismissed. And it also provides rights and remedies for trade unions. And there are also provisions relating to collective bargaining. So if you're a large organization which has a trade union, the rights of the trade union are governed by the Industrial Relations Act 1967. And the whole purpose of this act is basically to promote and regulate the relationship between an employer and the workman and the employee. And also, if the organization has a trade union, to govern the relationship between the employer and the trade union. It is also an act designed to cater for settlement of disputes. So for example, there is a dispute between the employer and employee relating to their terms of employment. There are provisions in this act which provides solutions for such disputes. And the fundamental aspect of this act, the Industrial Relations Act 1967, is to provide a balance between the right of an employee to their livelihood and also the right of an employer to dismiss or terminate an employee in justifiable circumstances. Now, ladies and gentlemen, it is important to note that a person's right to employment is a fundamental right provided under our federal constitution, under Article 5(1). And this has also been set out in the landmark decision of R. Ramachandran against the Industrial Court Malaysia and another. Basically, every person who is gainfully employed also enjoys security of tenure. And in the event there is an encroachment, there is a breach, an employee has been unlawfully terminated from his or her employment, then that person can seek appropriate remedies for wrongful dismissal or statutory unfair dismissal. And in Malaysia, when an employee considers himself to have been dismissed without just cause or excuse, without a valid basis by the employer, the employee then may make a representation in writing to the Director General of the Industrial Relations Department under Section 20 of the Industrial Relations Act 1967. So basically, as an employer, it is very important for you to take note that a person's right to livelihood is provided not only under our statutory laws, but it is also provided under our federal constitution. And the acts that have been implemented, such as the Employment Act and the Industrial Relations Act, have been implemented to cater for situations where this fundamental right is breached. So always be very, very mindful of this and be very, very careful when dealing with an employment contract. Always ensure that the rights of the employee are protected, and the right to terminate an employment contract is only exercised in circumstances justifying such termination. I will deal with that later on in my presentation. And now, in the event an employee or person's right to livelihood is infringed, as mentioned earlier, the employee or the person can make a representation in writing to the Director General of the Industrial Relations Department for unfair dismissal or wrongful dismissal. And a person who pursues a claim for unfair dismissal or wrongful dismissal is entitled to certain remedies provided for under the law. There are 3 fundamental remedies provided for under the law. The first remedy is the right to reinstatement. A person who has been unfairly dismissed can seek reinstatement to his or her former position with the company. So for example, you are a general manager with a company, you have been terminated by the organization, and you feel that you have been wrongly terminated. You bring a claim for wrongful dismissal, and your claim for wrongful dismissal is upheld. You can then seek reinstatement to your former position. You can seek to be reinstated to the position of general manager with the company. Apart from reinstatement, a person or an employee who has been wrongfully dismissed can also seek compensation in lieu of reinstatement. And this is the remedy that is usually granted. Very rarely do the courts order reinstatement. The courts would usually order compensation in lieu of reinstatement. And the quantum of compensation that will be awarded will be will be based on the number of years the employee has been continuously employed. So for example, you are an employee who has been employed for 10 years by a company, and then you have been terminated. You bring a claim for unfair dismissal. Your claim is upheld. The court finds that the employer had wrongfully dismissed you. The court can then order compensation, order the employer, order the organization to pay you compensation. And if you have served the company for 10 years, you are entitled to 1 month salary for each year of service of your last drawn salary. So if you have served 10 years, you are entitled to 10 months of your last drawn salary. So the longer a person is employed, the more wages, or sorry, the more compensation they are entitled to. And apart from compensation, an employee who has been wrongfully dismissed is also entitled to back wages. Back wages is also a form of compensation which covers a specific period. It covers the period from the date of your dismissal until the conclusion of the hearing in the industrial court, or until an award is handed out, up to a maximum of 24 months. So for example, the period between your date of dismissal and the conclusion of the hearing in the industrial court, or the handing down of the award by the industrial court, takes, say, 4 years. The law states that you are only entitled to 2 years back wages. You cannot get back wages for 4 years. So there's a cap. Okay. So this is just the overview of some of the remedies that an employee who has been wrongfully dismissed is entitled to if he or she is able to prove a claim for unfair dismissal. Now I will move on and deal with the issue of termination, which is the main subject matter of our webinar today. Now, let me first take you through the forms of termination of an employment contract in Malaysia. An employment contract can be terminated through various forms. One is through the dismissal of an employee by the employer. So, for example, the employer finds that the employee has committed some acts of misconduct, or the employee has been a non-performing employee. The employee has failed to meet his or her KPIs, etc. So the employer decides to exercise its rights of termination by terminating the employment contract entered into with the employee. Another way in which an employment contract can be terminated, this is very common, through the resignation of the employee. So for example, as an employee, you have decided that you want to leave your current job. Perhaps you have got another offer, or you want to look at another form of employment. You can then tender your resignation as provided for under your contract of employment, and you can bring the contract to an end. Your employment contracts will usually have a notice period which you would have to serve. Usually it's between 1 to about 3 months, depending on the position you hold and the number of years you have served the company. So you can bring your employment contract to an end by serving a notice of resignation. Another way in which an employment contract can be brought to an end is through the mutual consent of the employer and the employee. So for example, the employer and the employee come to an agreement and they say, look, we would like to end the employment contract. We would like to bring it to an end. They can do so through a mutual consent. And this is usually in the form of a mutual separation scheme or a mutual separation agreement, where for a certain reason, the employer and the employee decide, okay, let's bring an end to the employment contract. Another way in which an employment contract can be brought to an end is through the expiry of a fixed-term employment contract. Like I explained to you earlier, a fixed-term employment is where you employ a person for a specific duration, a specific period of time. And once that period of time has lapsed, the employment contract is automatically terminated. It automatically comes to an end unless it is renewed. And another way in which an employment contract can come to an end is through the operation of the law. For example, the employment contract is frustrated. I will explain this to you shortly. Now, let's deal with the first aspect, which is termination of an employment contract through the dismissal of an employee by the employer. Now, under the law, an employer has the right to hire and fire. The power to dismiss an employee is considered to be the prerogative of the employer. An employer is entitled to hire or fire any person it deems fit for the effective and viable running of its operations of its business. However, if an employer decides to dismiss an employee, the dismissal must be with just cause or excuse, as provided for under Section 20 of our Industrial Relations Act 1967. So whilst an employer has a right to fire an employee for the effective and viable running of its business, it must ensure that it only terminates its employee in justifiable circumstances, failing which the termination would be held to be unlawful. And of course, an employee may be dismissed from employment on various grounds. And this includes, but it's not limited to a situation where the employee commits acts of misconduct or the employee is a non-performing employee. He or she fails to perform a job scope. But there are, of course, various other grounds in which an employee may be dismissed. Now, I would like to deal with the issue of misconduct. Now, misconduct is the most common ground for dismissal in Malaysia and in fact throughout the world. Most employees who are dismissed, who are terminated by their employer are usually done on the grounds of misconduct, where the employee has done something so wrong in breach of their terms of the employment. Misconduct basically concerns the unacceptable behavior of an employee during his employment with the company. So, for example, an employee who is absent from work for a period of time without prior leave, without permission from the employer, an employee who is habitually late to work. So, for example, your working hours are from 9 a.m. to 6 p.m., but the employee regularly comes in at 10 o'clock or 11 o'clock in the morning. So it's habitually late. That may be a ground. That would constitute a misconduct entitling an employer to terminate the contract. Or there are other instances of unacceptable behavior by the employee. For example, committing theft, sexual harassment at work. So there are various grounds in which an employer may terminate an employee for misconduct. Now, whether or not an employee has committed an act of misconduct, of course, depends on the facts and circumstances of each individual case. And in order for the employer to terminate an employee for misconduct, the employer must, of course, prove that the employee has indeed committed such misconduct, and the employee was given an opportunity to answer these allegations of misconduct. And upon hearing the employee, it is established, yes, the employee has indeed committed these acts of misconduct, then the employer may terminate the employee. I will come to the procedure of termination a bit later. Let me just deal with this issue of termination first. Now, like I mentioned earlier, examples of misconduct are like insubordination, absenteeism, even drug abuse. There have been cases where the employee has been found to have been in possession of dangerous drugs or consuming drugs. This is, of course, a serious misconduct which entitles the employer to terminate the employee. Theft, like I mentioned, dishonesty, sexual harassment, and the list goes on. Now, another ground in which an employer may terminate an employee is incompetence, where the employee fails to perform. An employer is, of course, not bound to retain an employee who has demonstrated poor work performance. But however, ladies and gentlemen, this is very, very important. An employer should refrain from terminating an employee just because he or she has performed poorly, unless sufficient opportunity has been given to the employee to improve his or her performance And after these opportunities have been given, and yet the employee fails in his or her duties, then the employer may consider exercising the right of termination. But please remember, when it comes to poor performance, incompetence, the employer should always give sufficient opportunity to the employee to correct himself or herself. And the employee must be warned that if he or she fails to improve his or her performance, then he or she faces the risk of termination. There are cases to this effect, and one of the cases which I've highlighted in my slides is the case of Rooftech Sendirian Berhad against O in Penang. And like I mentioned earlier, an employee should be very slow to dismiss an employee on the ground of incompetence. The employee should be given sufficient warning and opportunity to improve his performance before the employer considers exercising the right of termination. Now, moving forward, dealing with the resignation of an employee, this is fairly straightforward. As mentioned earlier, an employee is entitled to terminate his employment by tendering his resignation. The resignation, of course, has to be in accordance with the notice requirements stated in the employment contract. So, for example, if the employment contract states that an employee who wishes to resign must serve 2 months' notice, then it is imperative that the employer gives 2 months' notice. This notice requirement may, however, be waived with the consent of the employer. And usually, in certain situations, the notice requirement is waived by making payment in lieu of notice. And it could work either way. So, for example, an employee who has resigned and has to serve 2 months' notice, but the employer, knowing that this employee is already going to resign, is already going to leave the employment, and the employer now wishes to engage somebody else as quickly as possible to take over this position, the employer can then waive the notice requirement by paying the employee 2 months' salary in lieu of notice. Likewise, an employee who wishes to leave an employment on an urgent basis, as opposed to serving the 2 months or 3 months notice period, may make payment in lieu of notice, provided this is accepted by the employer. Please, however, remember that an employee who is forced to tender his resignation due to acts of oppression or victimization by the employer may then consider himself or herself to have been constructively dismissed and may then bring a claim for constructive dismissal against the employer. So, for example, the employer has treated this employee very badly. The employer has not terminated the employer, but has treated this employee very badly and has just failed to reward the employee for good performance, or just made life very difficult for this employee at work. This employee may then tender his or her resignation and seek or bring an action for constructive dismissal on the basis that he or she has been forced to resign due to the oppressive act of the employer. Moving forward, like I explained earlier, an employment contract can also be brought to an end through the mutual consent of the employer and employee. This is the most trouble-free form of termination because it's done through the mutual consent of both parties. And usually when a contract is terminated through the mutual consent of both parties, there would be an agreement in place, a mutual termination agreement or a mutual separation scheme to record the fact that the termination has been, the contract of employment has been brought to an end on mutual grounds. So then the employee cannot bring a claim for unfair dismissal or wrongful termination against the employer, and the employer likewise cannot have any claims for breach of contract, etc. against the employee. And of course, another situation is through the expiry of the employment contract. This applies in fixed term contracts where there's a fixed term or fixed duration of employment. So the employment contract will come to an end at the expiry of that duration. And finally, ladies and gentlemen, a contract of employment can also be terminated or brought to an end through the operation of the law. One example is frustration. So this is where a contract of, or rather, due to unforeseen circumstances or unavoidable circumstances, the performance of the employment contract is no longer possible. So the contract can then be brought to an end. And when does this happen? This could happen, for example, due to the death of an employee. So for example, an employee passes away. So naturally, the contract of employment will come to an end. Or say, for example, the employee suffers permanent injury. Say the employee meets with an accident and suffers permanent disabilities, permanent injuries, rendering him or her unable to continue his employment with the organization. Then the employment contract may be brought to an end. Or for example, where the employee suffers a prolonged illness, terminal illness, etc. And of course, in a situation where an employee has been convicted under the law, he or she has been imprisoned, for example, then naturally the employment contract would also come to an end. And there are other circumstances like change in the law, there's a war, etc. In a situation where we are dealing with expatriates, foreign employees, say for example, for some reason, the work permit or the visa of the employee cannot be renewed, and the employee has to return back to his or her country of origin, then of course, the employment contract will also come to an end under such circumstances. Now, moving forward, I will now deal with the procedure on the termination of employment. Earlier, I took you through the circumstances in which, or the forms in which an employment contract can be brought to an end, can be terminated. Now, let me take you through the procedure on the termination of an employment. This is especially in a situation where the employer decides to terminate the employment contract of an employee on grounds of misconduct or poor performance, particularly grounds of misconduct. Now, in order for the employer to be entitled to terminate the employment contract, the employer must of course give reasonable notice to the employee. So for example, where the employee has committed an act of misconduct, say for example, the employee has committed theft at the workplace. The employee has taken property or monies belonging to the company. So the employer now wants to terminate the employee. Before doing so, the employer should give reasonable notice to the employee of his act of misconduct. And the employee should be given an opportunity to be heard. So for example, as an employer, you have found that this employee has committed a misconduct, has committed theft, as I mentioned, and you want to terminate him. Before doing so, you should give him notice that he has committed an act of misconduct, he has committed theft, and you should also give him an opportunity to explain, or an opportunity to be heard, okay, on why he or she did such an act before you exercise your right of termination. And of course, the employer must also carry out a proper investigation. You must be extremely sure that that particular employee has committed the act of theft. There must be evidence to show that that employee has committed theft. If you don't know, if you don't have proper evidence, then you wouldn't have a right to terminate. And if you do so, as mentioned earlier, your termination could be found to be unlawful. And some organizations will, of course, have an employee handbook. This employee handbook may set out procedures in which an employee, the procedures on how an employee should be terminated. Should there be an act of misconduct or should there be poor performance? Then such procedures as prescribed under the employee handbook should be adhered to, should be followed by the employer. Now, coming to the point of giving notice to the employee who has committed an act of misconduct or who has been guilty of poor performance, the notice to be given is usually called a notice to show cause. This is the starting point before the employer takes any disciplinary action, including termination of the employment. Okay. What should this notice of show cause set out? This notice should set out the alleged misconduct by the employee and set out, or if it's a situation of poor performance, set out details of the employee's poor performance. So now just say it's a misconduct, and I come back to my example, the employee has committed theft. So your notice of show cause to the employee should set out details like what act of theft was committed. So for example, if the employee has stolen money from the company, you should set out when this act was committed, how much was stolen, and any other details pertaining to this act of theft. And for example, you have evidence showing that he or she has committed this act of theft. Like say, for example, there is CCTV footage. Maybe you can refer to that in your notice as well. And like I mentioned, the employer should provide reasonable opportunity to the employee to furnish a reply, to state his or her views on the allegations raised against him or her. And the notice should also set out a time period for the employee to respond to the allegations. Normally, the notice of show cause will provide the employee maybe with a 7-day time period or maximum 14-day time period to respond to the allegations raised against him or her. And if the employee fails to furnish a reply within the time period stipulated, provided the time period is reasonable, then the employer may proceed to make a decision. And this includes taking disciplinary action such as possible termination of the employment if it is warranted. And in a situation where the employee has committed an act of misconduct, like theft, for example, and after you have given notice to the employee, if the employee admits to having committed this act of theft, then the employer has an automatic right to terminate the employment of the employee because the employee has already admitted to committing such an act of misconduct. Now, in cases of serious misconduct, such as theft, or even in situations where there is, say, for example, sexual harassment at work, before you terminate the employee, you may want to conduct a thorough investigation. The fact-finding mission, the evidence-finding mission. During this period, when the investigation is carried out, you may suspend the employee because you don't want any interference with the investigation. But suspension pending inquiry, suspension pending investigation should only be carried out in fit and proper cases. Not in every case you should suspend the employee, only in cases of serious misconduct where a detailed investigation needs to be carried out and the time needs to be taken for this investigation, then you may suspend the employee during this period. And usually the period of suspension should not be longer than 1 or 2 weeks. You should be able to complete your investigations within a maximum of 2 weeks. And if an employee is suspended for an indefinite period or for an unduly lengthy period, then the suspension could be deemed to be unreasonable and it could be a breach by the employer. So be very careful. If you intend to suspend your employee pending investigation, try to keep it quick, maximum 1 to 2 weeks. Conclude your investigation and then you take the necessary steps moving forward, or else your suspension could be deemed to be unreasonable. And if you suspend your employee during the period of suspension, the employee should still be paid his wages, at least half of his basic wages. And for example, in certain situations where you need to suspend the employee for more than 2 weeks, say example, 3 weeks or 4 weeks, then it is recommended that the employee be paid his full wages after the initial period of 2 weeks. This is set up, for example, under Section 14 sub 2 of our Employment Act 1955. And if the inquiry or the investigation does not disclose any misconduct on the part of the employee, then the employer must restore the employee to the full amount of the wages which was withheld during the period of investigation. However, ladies and gentlemen, in the interest of fair labor practice, it is advisable, it is encouraged that even during the period of suspension, an employee be paid in full, including all his benefits that he's entitled to under his employment contract. Now, I will move on. Now, I will very quickly deal with domestic inquiry. Okay, what is a domestic inquiry? A domestic inquiry is an internal investigation process conducted by the employee on the conduct of the employee, conducted by the employer on the conduct of the employee. And a domestic inquiry is usually conducted in cases involving serious misconduct by the employee. A domestic inquiry is basically a domestic hearing, a hearing conducted by the employer. So the employer will sit down with the employee. The employer will then set out the details of the acts of misconduct against the complaint against the or raised against the employee. The employer will adduce all the evidence in support of those allegations, and the employee will then be given an opportunity to respond to all these allegations. And once this is complete, the employer can then make the necessary decision whether to terminate the employee, whether to suspend the employee, or if it is shown that the employee actually did not commit the act of misconduct, or the employee has a satisfactory response to the allegations, then maybe the employer may just drop those complaints, and the employee can then continue his or her employment with the company. When conducting a domestic inquiry, the employee should be notified of the date, time, and venue of the hearing. And like mentioned, the employer must notify the employee of the complaints or the charges framed against him prior to the conduct of the hearing. So the employee has advance notice of the complaints made out against him, so that he or she has sufficient time to prepare a response and to address these issues during the domestic inquiry hearing. And like mentioned earlier also, the complaints, the charges must contain full particulars, including the time and place of the alleged misconduct against the employee, or the alleged misconduct by the employee. During a domestic inquiry, the parties must appear in person and cannot be represented by a lawyer. This is not a court. This is just a hearing within the confines of the organization. It's an internal process. So the employer and the employee cannot be represented by lawyers. They must be personally represented. And during the hearing, the employer, like I mentioned earlier, will first present its case. If the employer has any witnesses or evidence to establish the charges against the employee, this will be presented. And thereafter, the employee will be given an opportunity to respond to the charges against him. Sorry, I think there's a slight typo error in the slides. It should be against him. When this domestic inquiry is conducted, the employer will usually form a panel of maybe 3 persons consisting of the upper management of the company, who will be tasked with investigating, who will be tasked with conducting this domestic inquiry and making an appropriate decision. And once the hearing is concluded, this inquiry panel will make a decision on whether the charges framed against the employee has been proven on a balance of probabilities. And if the panel finds that the employee has indeed committed misconduct, it must then mete out the appropriate punishment, which should be commensurate with the circumstances of the case. The punishment that can be imposed by the inquiry panel includes termination, or perhaps demotion of the employee, suspension of the employee, or a lighter punishment if it's a less serious offense. So lighter punishment such as a warning. An employee who's dissatisfied with the decision of the inquiry panel may appeal against the decision made. And if there is an appeal, the appeal may be heard by another inquiry panel, another independent inquiry panel. The panel who heard the original or who conducted the original domestic inquiry cannot hear the appeal. It must be by another set of by another panel. It must be heard by another panel of the company. Now, moving on. Yeah, that deals with the procedure insofar as termination is concerned. So just before I touch on my final area of my presentation today, just to recap on the issue of termination, like mentioned earlier, there are a few circumstances in which an employment contract can be terminated. And I think the area that is always contentious is where an employer decides to terminate an employee due to misconduct or due to poor performance. And in such a situation, before the right of termination is carried out, the employer should give notice to the employee to inform him of the alleged misconduct or to inform him or her of his poor performance. The employee then must be given a right to be heard. It is encouraged in cases involving serious acts of misconduct that a domestic inquiry be held, a domestic inquiry hearing be held. And after all these procedures have been exercised, if it is then established, yes, there is strong evidence to show that the employee has indeed committed such acts of misconduct, then the employer may proceed to exercise the right of termination. If the complaints made out against the employee is less serious, then other forms of punishment can be meted out, such as, like I mentioned earlier, demotion or a suspension, or in less serious offenses, maybe the employee can be let off with a warning. Now, there's not too much time left because after this, I need to give some time for Q&A as well. So I'll just very quickly touch on the area of retrenchment. Now, this is an area of particular interest over the last 2 years because of the COVID-19 pandemic, where many businesses have been badly hit. A lot of businesses could not operate physically during the implementation of the movement control order. So a lot of employers have sought to lay off or terminate some of their employees because they have become redundant, or the employer can no longer afford to keep them in employment. So a retrenchment, can you just go back to the earlier slide, please? A retrenchment is basically the termination of an employment contract due to redundancy. And this could arise by reason of closure of business, restructuring, reduction in production, mergers, or downturn in business, like I mentioned, due to the COVID-19 pandemic, etc. And a retrenchment exercise is carried out when the employee becomes surplus to the requirements of the company. But it is important to note that a retrenchment exercise should not be carried out willy-nilly by the employer. It should only be exercised or carried out as a last resort after all other avenues have been exhausted by the employer. In a situation where the employer faces a downturn in business, like for example, over the last 2 years, where many businesses have been badly impacted by the COVID-19 pandemic, before the employer, before the organization decides to exercise retrenchment, the employer will first have to satisfy the following requirements. In fact, our Malaysian government in circulars previously issued have set out these requirements that need to be complied with by any organization before they decide to exercise the right of termination or right of retrenchment. Firstly, there must have been a genuine financial impact of the business of the company. That means your business must have been seriously affected. This must be shown through your financial records. then the employer must also have exhausted all other cost-cutting avenues, such as the reduction of the working hours of the employees, or freezing or limiting new hires, limiting overtime, limiting work on weekends, or possibly reducing the wages of the employees, or even maybe laying off employees for a temporary period, maybe during the movement control order period, especially like, for example, we were faced with phase 1 where many businesses could not operate physically. So maybe during that period, you could temporarily lay off certain staff who are surplus to requirements, and then rehire them once you're able to operate fully again, operate physically. And it is also important to note that if you're an organization which has foreign employees, foreign staff, the services of the foreign employees should be terminated first before you terminate local employees. And insofar as local employees are concerned, if you exercise the right of termination, you must adhere to the last in, first out principle. This is where you first terminate the employee who are the most junior in service in the company. The most recent employees who you have hired, last in, first out. And if these circumstances are not established, then your retrenchment exercise could be deemed to be unlawful, and the employee may then have a right for unfair dismissal against the organization. So, ladies and gentlemen, this brings an end to my presentation. And before I conclude and before I hear any questions that you may have, I would just like to let you all know once again, or like to impress on all of you, especially employers, that at the end of the day, an employment concerns a person's fundamental right to livelihood. So the right of termination should be exercised only in appropriate circumstances. In fact, like any other contract, even any other commercial contract that you enter into, termination is always a very contentious issue, is always a very dicey issue, more so in an employment contract because it concerns a person's livelihood. So only exercise such a right if the situation really warrants the exercising of such a right. And I've always advised my clients that it is important for there to be open and transparent communication between the employer and employee, so that a harmonious working environment can be created and any employment related issues can be addressed and resolved in an amicable manner. And like I mentioned, if an employer decides to exercise the right of termination, then proper procedures must be adhered to. And before the right of termination is exercised, the employee must be given a reasonable opportunity to be heard. That is all, ladies and gentlemen. I hope you found my presentation insightful and you've gathered some knowledge. And I will now hear some questions. Thank you, ladies and gentlemen, for listening in.
Thank you, Mr.
Aini,
Rohan.
over to you.
Thank you, Mr. Rohan, for the enlightening sharing. I'm sure it's very helpful to many of our attendees today. Okay, so now we have come to the Q&A session for this webinar. You may post your question in the Q&A chat box if you have any questions, and you may also click the raised hand button below, and we will allow you to verbally ask a question to Mr. Rohan. And I see there are two questions here. So the first question is from Ming Lu. So hi, Mr. Rohan, can employer hold employee salary if they didn't hand over properly their job to others? So could Mr. Rohan answer this question first?
Sorry, Aini, can you just repeat that question again, please?
Okay, can employer hold employee salary if they didn't hand over properly their job to others? So that's the first question.
Can you hold over an employee's salary if they did not hand over their job properly? Generally, strictly speaking, under the law, you should not withhold an employee's salary. This is always viewed as a fundamental breach. So I would not advise you, against holding an employee's salary. Unless the situation really warrants it. So I'm not too sure what you mean by not handing over properly. I assume in a situation where the employee has already resigned and he or she is supposed to hand over duties to the incoming person, and a proper handover is not done. Even in such a situation, I would not recommend withholding the person's salary. At the end of the day, that person is already going to leave the employment. And to avoid a situation where the employee may then bring any claim for wrongful withholding of salary, etc., it is not advisable to withhold an employee's salary.
Okay, now moving on to the second question from Tiffany. Regarding domestic inquiry, could you please elaborate more on the following? The first one, who are the members of the inquiry panel? And B, what are their roles? And the third one, the hearing procedures.
Okay, the inquiry panel will usually consist of senior members of the company's management. For example, a director of the company, or a CEO of the company, or the CFO of the company, the people in the top tier of any organization. And usually an inquiry panel will consist of 3 people. There will be a chairman with 2 other members of the management sitting in as part of the inquiry panel. And basically, like what I mentioned earlier, during the domestic inquiry, the inquiry panel will read out the charges framed against the employee, and the inquiry panel will present whatever evidence that they have in support of the allegation. So for example, again, I just come back to one example, the example of a theft. So an employee here has been alleged to have committed theft in the office. And say, for example, there are eyewitnesses. There are other employees within the company, within the organization, who saw this particular employee taking monies belonging to the company dishonestly. These persons may then be called as witnesses during the domestic inquiry, and these people then, or these persons, can then relate to what they saw during the incident. And if there's any other evidence that you have, for example, there's a CCTV recording, CCTV footage, this footage can be presented during the domestic inquiry. And after you have presented the complaints and the evidence in support of these complaints, you then give an opportunity to the employee to say his or her piece. So the employee can then present his or her defense to the complaints. And thereafter, after having heard what the employee has said, if the inquiry panel finds that there is overwhelming evidence showing that the employee has indeed committed this act of theft or this act of misconduct, then the inquiry panel can make the appropriate decision. And in cases of serious misconduct, the employer can, of course, exercise the right of termination. So the inquiry panel can then communicate this to the employee. I hope I answered the question. Yes.
Okay. Now, the third question from Wendy. So she wants to know if 3 days consequent absent without any notice, is it possible to terminate directly?
3 days. Okay. If you look at the law, if an employee has been absent from work for more than 48 hours without leave, without prior permission of the employer, then the employee is deemed to have committed a serious act of misconduct, warranting termination. But before you terminate the employee, in line with good labor practice, it is advisable that you still issue a show cause notice to the employee and give the employee an opportunity to explain why he or she has been absent from work for more than 3 days without leave. What has happened? Why has he or she not turned up at work? And if they do not have a satisfactory explanation, then the employer may possibly go ahead and terminate the employee. Yes.
All right. Thank you, Mr. Rohan.
No
I see there are no more questions for Mr. Rohan. So I believe that's all the time that we have today. So this marks the end of our webinar. Thank you very much, everyone, for joining us. Goodbye and stay safe, okay? Thank you.
Thank you, Aini. Thank you, everyone. Have a nice evening.